Your tires and has made threatening comments to her. She's concerned he might return.
I forgive this at 32.
10-4. 532, you're assigned to a vandalism case in Athens. Can you copy the final fact?
10-4.
I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the alert.
10-4. 449-1120.
Now 449-1121, thank you.
10-4.
Code 4.
Alright, we have 535.
Yeah, that was a great college.
535.
Should be. You got no for a woman who fucked into a house. I'll fight up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get it out. He's now 5 foot, long dark hair, got tie-dye shirt on. Number 21 is on.
Switch is on, here comes the throttle. Circuit breakers in. We have separation. Inboard and outboard, they're on. Coming forward with the side stick.
I've got a blowout. Neighbor 3. Pitches out. I can't hold it out for 2.
Direction Alpha. Trip flight is emergency.
Flight call. I can't hold it. She's breaking up. She's breaking.
Ladies and gentlemen, welcome to the main event. Let's get ready to rumble!
Y'all ready for this?
I think we'd rather listen to this than me. I know I would. We used to have to play this song down the bar a lot. I actually really like this song. What's the name of that Let's Get Ready to Rumble guy? God, I forgot his name. Well, thanks for putting up with me. I like to hear that. And this Sunday, it's going to be a heavyweight bout and equally matched. Different styles. Yeah, different sets of experience to draw from. In this corner, wearing turtle green trunks, weighing in at 140 pounds, Aiden Kearney, 10 years experience blogging and podcasting. In this corner, wearing red, white, and blue trunks, weighing in well north of 200 pounds, Sean the Gulf McDonough. 8 months podcasting experience, but also many years of law enforcement. Styles, well, we saw Aiden's style in the wiretap interview of Scanlon. He will patiently try to bait you into a trap. In numerous shows, we've seen Sean's impressive style. His approach is to try to dominate with interruptions. Quick to sense the trap. He'll try to lead the conversation away by throwing in topics that are tangentially connected, but which are more or less irrelevant. In an emergency, he'll throw out, well, you guys weren't in law enforcement, so you don't understand. So, to be honest, these guys are both heavyweights. It should be a pretty good battle if it turns out to be a battle. So what's their beef? Well, Aiden says that nothing Sean reports ever proves accurate, and nothing he predicts ever comes true. This is, of course, actually accurate. It's true. But it's hard for Sean to dodge this if Aiden uses it. I mean, it's how are you going to get around that? Because it's true. Sean's batting average is actually lower than Pedro Martinez's. Makes Pedro look like Ted Williams. In fact, Sean's batting average might be similar to what mine would be if I was facing Pedro in the batter's box. So Aiden has been jumping all over this lately. So what does Sean have to say on Aiden? Well, Sean says Aiden is a rat, that the state of Massachusetts flipped him. And make no mistake, that's what he's saying. When he says he was suspicious when Aiden tried to contact Sean 2 hours after being released from jail, it wasn't Aiden's device trying to contact Sean. It was Aiden. If you ask me, this is just another example of Sean's batting average. The guy is always wrong. Mello seemed to be stretching the bounds of credulity last week and trying to keep Aiden in jail. So the state wouldn't do that if they actually had flipped him. I don't know how many times Sean gets to be wrong before the zombie horde begins to question him, but zombies are not known for their processing speed. So I'm going to go with they just never question him. If he reports it's snowing in Naples today, the horde will plan a ski trip to the Sunshine State. So I don't know how Sean wins this battle against Aiden, but who knows? And Aiden also has a lot of false reports on his resume. Maybe Sean will point them out. There's the non-human hair. There's Proctor being suspended or fired. But, to be fair, we all get some things wrong. I reported no true bill this fall. So we all do get some things wrong. I want to look at very quickly more Alan Jackson trickery. This is something that I had not picked up until last night. So let's check this out very briefly.
Desperate
pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI.
A Quantico-trained special agent with the FBI.
Regional Computer Forensic Lab. In other words, the United States Federal Bureau of Investigation also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022.
So what is he not saying? I mean, is he saying that the FBI's the division is called, hold on a second, I actually looked it up for you guys to see what it was called and reported this today. This was this is the FBI's where their forensic data division is. All right, it's called the Laboratory Division of the FBI, and they're the ones that do the forensic data analysis for the FBI. Now, he did not say, and they're part of the STB. That's the overall division that they're in. And you notice that he doesn't say that the FBI's laboratory division or their forensic specialists concluded this. He's mostly just trying to say it's an agent. So somebody they got down there, and we don't really know the context. He does, yes, unsafe. He does say the FBI's Regional Computer Forensic Lab. So it's not really clear, though. He always takes things out of context, all right? And you find this out much later or sometimes quickly later. And so what exactly is he saying here? We don't know until we see the report. But it could be as simple as in an early part of a report, an agent quotes Rich Green. And then Alan Jackson takes that and quotes that to kind of say, that's what we're talking about, that to say, aha, see, they said the same thing. So until we see the reports on any of these things, we really don't know. And Alan Jackson's famous for the trickery. He did a lot of trickery last Tuesday, and we're gonna be streaming this at 2:00. These things, because there's other hearings going on, we don't know exactly if it'll start on time, but we're gonna try to see, but we're definitely gonna stream it for you guys. I don't know where it'll stream either. So as we get to about 5 minutes I will go to all the usual sources, and then you guys can be looking too. And whoever finds it first, I'll give you a nickel. Hopefully, but I may find it first too. Often it's on WCVB Channel 5 Boston on their website. But a couple of times ago, we found it or somebody found it for us on Fox 25's YouTube site. Another time it was on the Fox 25 site. So we always find it, and it's usually like a couple of minutes before it starts. So sit tight, but keep looking for us too, because we appreciate the help. And I appreciate the help. If you can find anything that so we're going to open up WCVB and all the different things and see, and we'll find it eventually. All right, let's see what else we got in the news. I just was playing around today or over the last week with ChatGPT or similar programs that are fueled by these text AIs, which can do text to image. This is all in fun. I know somebody might get upset about these things, but we're just having a little bit of fun. And you put in some text parameters and you see what the image generator produces. No actual photos are used. It's just all text to image. So sometimes they get it close and sometimes they don't. I'm sorry. It was fun for me. Maybe it's not fun for everybody, but this was just what they came up with. So Grant has said today that a possible reason, everybody's speculating, so you have to be cautious about this stuff. But now I can take these off for now, I guess. So David Yannetti's sister has been added to the defense team, and I saw that was approved. Does that mean anything? I mean, I really have no idea what it means. I don't know anything about her. I don't know if she has a particular expertise. Somebody, I think it was Grant, or might have been somebody else, was speculating on Twitter that David Yannetti had been removed, so his sister took her place. I would be shocked by that. Maybe she just brings in a particular expertise that other people don't have, or this is kind of, if you live in this region, the trial of the decade, right? And so what a chance to get some actual trial experience that would benefit anybody, right? So, but I have no idea what her experience level is. But I mean, I would think, you think back to the OJ case, for some of you guys that are old enough to remember it, bring in, there were a lot of guys that were brought in that were very, very famous attorneys, such as Alan Dershowitz and F. Lee Bailey. It was kind of a dream team. But some of the other guys that were, some of the other people that were less famous ended up kind of dominating the procedure. I can't remember his name, the black attorney that said, if the glove doesn't fit, you must, it's at the tip of my tongue. But he was probably the best attorney there. Some of the prosecutors became famous out of that too. And also even some of the people that were covering that at the time. Greta Van Susteren went on to fame and had a big show out of that. Wow. Johnny Cochran. Yeah. Johnny Cochran was great. They had a character that they made up on Seinfeld that was kind of to mimic him. That was, what a great lawyer he was. He died young too. Too bad about that. Coffee Kristen, welcome back. I accidentally banned Coffee when I slipped and hit the wrong ban button when someone else was being obnoxious last week. But good. I felt really bad about that. Good to have you back. Bucks in 6. Wow, a basketball fan. I'd actually be from Milwaukee too, to remember that thing that the Bucks fans were cheering. What was that, 4 or 5 years ago? For a couple of seasons, they were cheering that against the Celtics. Bucks in 6. Well, I don't know about this year either. Bucks in 6. If they beat the Celtics in 6, assuming they play the Celtics had to choke pretty bad, because the Celtics have played pretty well against Milwaukee over the last few years, and on paper the Celtics are a lot better than Milwaukee, but it could happen. Milwaukee does have a very good team, and they have a championship pedigree, and I don't trust this as on paper. The Celtics are as good as anybody and better than anybody except Denver right now, but I don't trust their ability to win close games. So we'll see what happens. I don't know about Bucks in 6. But yeah, he's talking about, now we have Sean grifting off the neighbors. I mean, we saw that report a couple of days. I'm not even talk about it because, like I said, his batting average is unbelievably terrible. Everything he reports ends up coming to be not true. So why feed it? And what I've looked into it, and from everything I can find, it's completely untrue. But whatever, he can do what he wants with it. I did see that he's doing a show on John tomorrow, so I encourage that. Do more of that kind of stuff. Positive memories about a good man that is gone. So I really do encourage that. Although, how do you stack that next to the attacks on Paul, his brother, and accusing him of being part of the conspiracy? So I don't know. But again, you want to encourage the good things. So if he's doing a positive show tomorrow on John, let's encourage that. So looking through the comments now, you guys could bear with me a moment. I'm going to line up the stations so I have everything ready to go. So first, WCVB, Boston. That's seems to be the main go-to source that we found here. And I'm also put on the one we found before that, which was Fox 25 in Boston. And we'll link in to whoever gets it first. And I also believe at one time it was, we found it on the Boston NBC. Let's line that one up too. So the NBC Boston does have a story up now. Karen Reed due back in court. I can play that. All right, let's play that story. Put the headphones for this one. And despite having the volume, there is no volume on that.
Her trial next month. Her attorneys are seeking to have her murder charges dropped, citing new information from a federal investigation. Our NBC 10's Kirsten Glavin is live outside Norfolk Superior Court with the new developments from this high-profile case. Kirsten.
Yeah, as far as dropping those charges go, the judge says she will wait to decide on that. But we did speak with a law expert tonight, and he says he does believe this case is going to go to trial and that it's looking more and more like an uphill battle for the state. Defense attorneys for Karen Reed dropping explosive new details in court Tuesday about the findings of a separate federal investigation looking into John O'Keefe's death. O'Keefe, a Boston police officer, was found dead in a snowstorm back in 2022 in Canton. Reed is accused of fatally striking him with her SUV.
The federal investigators hired a professional reconstructionist, 3 PhDs, to look into exactly this issue.
Reed's defense attorney saying an independent expert concluded that O'Keefe's injuries were not consistent with the damage to Reed's vehicle.
In other words, the car didn't hit him, and he wasn't hit by the car. Period. Full stop.
The defense also alleging relationships between law enforcement and those closely involved were not disclosed. That includes texts between the lead investigator, his sister, and the Albert family, who lived at the home where O'Keefe's body was found. Prosecutors firing back that this is all a distraction from evidence.
What the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources.
I've been doing this for 16 years. Every single day, I've never seen anything like this.
Criminal defense attorney Ben Herbalist says these federal findings are a game changer. He adds that conflict of interests will likely pose challenges during trial.
If they don't believe him or they don't believe his integrity, and he's the one who's saying, I found this piece of glass, I discovered this piece of hair, and they believe that his integrity is compromised because he has an interest of the outcome because he is protecting the Albert.
I got to pause this here because this is the problem with this story is just so much ridiculousness. This guy is supposedly a defense attorney, but he has absolutely no understanding of how the process works. Michael Proctor did not find the piece of first of all, it's not glass, it's taillight plastic, and Michael Proctor didn't find it. There's a team called the CERT team that comes out and searches for it, and they found that. Another team searches the vehicle that's called the chem team, and they found any evidence on the vehicle, such as the hair and the DNA. Michael Proctor had nothing to do with it. And so it's just strange to me that these people are on news channels as experts and they say things like that, and they clearly don't know what they're talking about.
The whole case goes out the window for the Commonwealth.
Now, the defense.
So we just don't know. Again, they're saying, going back to at Jackson's words, we're listening to him describe things when he always describes things with word trickery. And he did it again last Tuesday when he described that that the state in 2022, it's not their fault that the state didn't use the software that was available in 2023 in order to find the search for how long to die in the cold at 227, which is just trickery and it's bullshit and it's deception. because there's no way, unless they have a time machine, that the state can use software and use 2023 software in 2022. It's crazy. Alan Jackson knows that. Okay. He does this kind of thing all the time. Library gap videos, that there's no gap in the library video. Those are motion triggered. And obviously nothing triggered the camera at that time in front of the library when Karen would have been going home. So the reasonable assumption is that she didn't go home that way. There was another way to go, and that's probably where she went. There's no non-human hair. All right. Which, if it was a non-human hair, that would be a big deal. A non-human hair would be like a fiber or something like that. So I'm told maybe it's on Court TV. So let's go check Court TV. We'll have it from here. Hold on one second and let me share it. It hasn't started yet, so okay, it's hard to tell if anybody is actually in court yet. We hear voices there, but you look at the side pews, there's no one there yet either. So I don't think they've filled the courtroom yet. So we'll see where it goes. This is Court TV. Hopefully, Karen Reed case motions. Hopefully, they will have it. It looks like they will. I've tried Court TV many times before, and they've never carried these live. So that'll be nice if they start doing that, because we'll just always link to it. But again, we're on Court TV. So if you're ever looking at this yourself, you can always find it here. But you can also, looks like maybe Court TV will start covering these things. But anyways, back to Alan Jackson's word trickery. You know, this is why you have to be so careful until you actually see the reports. You don't really know. So when he says that the feds hired reconstructionists and they found that there was no way John's injuries, well, what is he exactly is he saying? So for instance, the key thing definitely here is the state has to have an accident reconstruction theory that matches John's injuries to the damage on the car. But they're forgetting that one other thing. There's also the cocktail glass involved. And personally, the only way that I can make sense of the car hitting John in the front and still cracking the taillight is if he's holding the cocktail glass and the car hits it. And you gotta, people say that that's crazy. A cocktail glass couldn't do it. No, it absolutely could, especially a fairly heavy duty cocktail glass, because you got a 2-ton vehicle coming at 23 miles an hour. And it only took off the outer layer, the red layer on the corner of that glass. So it doesn't, you'd be amazed at how much power goes into vehicles like that. I actually yesterday was coming back from the gym, and as I was heading up the street, a police officer on a motorcycle went racing past me with the blue lights on. And I was probably about a minute or two behind him and didn't realize he turned on the same road that I was going. And it was because the local high school was getting out. There was a lot of traffic on the road. And so things were kind of blocked up there. But I got up to the scene right as the motorcycle cop was getting off the car. I didn't understand what I was getting to. I saw one car pulled over on the road. This is a single lane road here. Okay. And clearly something had gone on with the car. And then the local trooper was going over to talk and with his pad of paper out so he could get the information. But then I saw something strange over on the side in the bushes that divided the property from the next house, the two houses there. I saw 2 high school girls. Now, there was a lot of high school girls that were out. The track team was out jogging. So 2 of them must have witnessed what had happened. And they were over tending to somebody that was lying down in those trees, in those bushes. This was about 20 feet from the road. And this guy that they were tending to was conscious, and he had on a motorcycle helmet. And as I got closer and managed to just kind of sneak around the car, the SUV that was parked there, that's when I saw that smashed in front of the SUV on the ground was the motorcycle. And it was, it was probably totaled. And so for half a second, I'm like, what is going on here? What exactly happened here? But then I pieced it together. The kid or whoever was coming down, it was probably a high school kid getting out of school, whatever, but it was coming down that road, lost control of his bike, and skidded at a high speed into the SUV. So the SUV she was in her lane, the SUV driver, so she didn't do anything wrong. But the impact of that, the kid on the motorcycle going into the SUV launched him 20 feet in the air. And this is a road where the speed limit is probably 25 miles an hour. It's not like and at this time of day with all the kids getting out of school. I mean, so probably this kid was maybe speeding a little bit, but speeding means going 30 miles an hour in that spot. And that was enough to launch this kid at least 20 feet in the air where he landed. And hopefully he's all right. I didn't see anything in the paper about a fatality or anything like that. And he was lying there with the girls attending to him, and he was moving around. Or at least his head and arms were moving around. So hopefully he's okay. It was interesting to me that the cop, I don't know if he didn't notice him. I don't know if the girls hauled over. He's okay. I didn't see what happened, but the cop was just kind of calmly dealing with the driver and taking down the information. Thought it was a little odd. But you see, this is the thing. These situations are never, people never expect 100% as though in the way that you would expect them to. So and also another thing that I learned from this, or was reinforced from this, was the fallibility of human memory. So I was a pretty good witness, right? And that I came upon the scene fairly quickly. It's daylight, got to see a lot of what was going on. But the way I remembered it was that the motorcycle driver was lying on some fairly large, significant boulders in between there. And that was not the case when I went by today, and I saw there were boulders not far away, but really not where he could have been lying. So I misremembered. We'll get my ugly mug off the air, and we'll let Karen Reed take over.
Great, thank you. Hi, how you doing? Ryan.
I'm sure. Oh, I don't know. Usually it's just one of them. They're usually not both there.
Yannetti, California attorneys, are they going to be on Zoom?
They'll be on Zoom, but they won't be arguing.
Okay. Oh, he was here earlier.
So if Bucks and 6 is still here, we do play Milwaukee tonight, so that should be a good game. So any Celtics fans out there, they are playing the Milwaukee Bucks tonight. That should be a big game. I think that's 7:30. Want to mention a couple things too. On April 20th, at the prodding of our great member, Kerry Lama, we're doing a group trip to the Lizzie Borden house, if anybody's interested. So if you want to, we'll be setting this up once we figure out the exact restaurants. I think it's going to be Scotty's Pub. We'll meet afterwards for lunch. So we have to be there for, the tour begins at 11:30. It caps at 25 people. So if anybody's interested in joining us, this has nothing to do with Karen Reed. So, I mean, no fights, no Karen Reed fights. Everything's going to be friendly. This is the Lizzie Borden house. It's an hour-long tour. If anybody wants to join us, get in touch with me. That's April 20th. We'll be doing it. There'll be more information out on it. And then we'll have lunch afterwards at a place where you can buy a nectar if you prefer. And just reach out. We can figure it out. And also, we're working on a case, a very terrible case, but one that's unsolved. And we think possibly if enough people put their minds into it, you can make a difference. This is in Iowa. These are two girls that were killed in 2012. It's Evansdale, Iowa. And there's a lot of fascinating clues to this case. So I'm going to be looking into it, Dave McGrath, some other people. And I've also talked to Bill Noguera about it. And he's very intelligent guy. I've already spoken about the case. And just in the brief time that I gave it to him, he had a lot of insights. So let's see if we can maybe move the needle some small way on that case, or at least help bring some attention to it. And it's again, this is Evansdale, Iowa. If you guys could do me a favor, please. It's a very small favor. Just click subscribe. It doesn't cost any money. We have the very modest goal here of reaching 5,000 subscribers. So just take a kind gesture to someone who's trying to bring you something. Just go up there and hit subscribe. I promise you, nobody will come and knock at your door or start telemarketing you or anything like that. It's just a subscription. You can unsubscribe anytime. All it'll mean is you'll get some notifications when we're doing a live. That's it. Day-old bagels are great, Rich. You just got to toast them. Thank you, everybody, for being civil. We can always have civil discussion here. Opinions on both sides of this case are welcome as long as it's civil. Don't make me get Tom Fleming after you.
I guess she's signed to Dedham District now, Martha. So you could always just call her if it's not. Right.
Bucks and Sticks mentioned a ghost train fire in Sydney. Huh. Yeah, I'll have to look into that. Are Karen and Higgins still messing around? Probably not. Mark Sweeney, you still owe me that beer. We should also just mention, too, that someone who I didn't personally know had a couple of Twitter messages with, but Brian Riccio died. I don't know the circumstances of his death. Sounds like it was unexpected, even though he had health problems. So I don't really think about Brian Riccio, but, you know, we shouldn't hate each other just because maybe we have different opinions on these things. So let's just have a moment of respect for Brian Riccio. Steve, Fire Pit Fun. Good to see you, man. Haven't seen you the last few shows. We missed you. Yeah, we'll do something again on Andy Puglisi. I did like a couple months worth of research into that one, and then we started, me and Dave and Aaron and some other people began a documentary shoot on that, Tom Fleming, out last August 1st. So we'll try to pick that up again this summer, but we'll do another episode on Andy. But obviously, when we do that episode, Dave will be on for that one. Judy says Nettie looks like he's at a funeral. It's always hard to read into these things, like, because Karen usually looks so confident. You'd say, what does she know? But it's very hard to read into these things. Human beings have a wide range of emotions and things that they're going through. A possible reason for bringing on Yanetti's sister is maybe she's good at preparing the defendant for how to act in court, because one of the things we've all talked about is the jury is going to be studying Karen very closely. They'll study the witnesses closely, they study the lawyers closely, but they'll be studying Karen closer than anybody. And sometimes her behavior in court, I don't think it's going to have a positive impact on the jury. She's very kind of cocky and stuff like that. So maybe Yanetti's sister is an expert in how to prepare a defendant to behave. I've total speculation. I don't know anything about. I don't even know her name. Because we noticed it, that I assuming that is Yanetti's sister, and she seems to be paying close attention to Karen and sitting close to her. So maybe she's there to prepare Karen for trial. I myself have a kind of a different approach to these things, and I've been on a couple of juries. I don't really, it's funny, even because I spent so many years in the bar business and I studied people, their facial expressions, as if my life depended on it a lot of times, and you can take a lot of information from that and trust your instincts on those kind of things. But when it comes to criminal cases, I just try to focus on the evidence, because I don't trust my ability to evaluate somebody else's, what's going on in their head. Mark says this is to offset her looking like she's sitting alone in Yanetti. Yeah, maybe. I don't think, Judy, I don't think it's nepotism. It's nepotism is more like the government when where you're getting your cousin a job or your sister a job or something like that. They can hire. This isn't really a nepotism issue. They can bring on whoever they want. Rich Harrington said he heard Yanetti's sister is an expert on accidents involving giant cocktail glasses in the street. Well, I heard Karen is an expert on cocktail glasses, but yeah, I shouldn't say it. Will we find out if the trial is moving forward? I don't think we'll find that out today, because they're adding to the motions, but it's moving forward. There is nowhere, unless there's some secret evidence that we don't know about, and there's no reason they wouldn't have presented that in court last week, this trial's going forward. The burden of proof and trying to show that the grand jury did not have probable cause is it's a high bar to overcome. So we're going to get a trial here. DJ's sister is Tanis. You mean Yanetti? Sister is Tanis? Jules also thinks David looks nervous. I don't know. It's so hard to read into this stuff. You know, these guys, they got a lot in their mind. And so the attorney that was in the news, Urbelis and Yannetti, are not in the same building. All right, quiet, please. So let's.
Just reminding folks about the cell phone use, okay? About the ring of those cell phones, okay? Taking those cell phones, go off, and you'll love us. What should you do?
Roll.
We're going on the record.
Officer John, why don't you come up here? All rise for the court, please. Now, what we need, seated.
Good afternoon, Your Honor. We are on the record on Commonwealth vs. Karen Reed on docket 22 CR 117. Beginning with the ADA, can we have the parties state their appearances, please?
Adam Lally for the Commonwealth. Good afternoon, Your
Good
Honor.
afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DiStefano. And in his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion's allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from state police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides, with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no? And
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay, all right, so I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. we learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that, Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the self-recusal of the Scranton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right, it looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to provide them as well.
They're two separately filed motions, right? And
yes.
One of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. And I would note that the providers are on the second motion, except for...
that's three different people, or one different person on the second
One different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials, which belie much of what counsel claims that they say. Essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say is, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who, admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred, and continue to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for, from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard on the Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? great. So I'll hear you after I hear from Mr. Hennon.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so out of an abundance of caution.
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So.
Can I have one moment, Your Honor?
Yes.
You can tell the judge is not happy because she is determined that this trial goes in on time.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow, allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address is dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case, and he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I've represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Good afternoon, Your Honor. Attorney Peter Pasciuco on behalf of Kevin Albert.
All right, so you need to spell that last name.
Sure, it's
for us.
Pasciucco.
Good afternoon.
Yeah. Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or a cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them. And I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed. And it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January 29th.
Brian Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th. That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call from or with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute, then another call with Albert for 10 minutes, then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly.
I'm sorry, I just need to, so at that point, you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
that's why I asked. So
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
What do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third party counsel if they want to be heard.
Your Honor, if I may, just one
Sure.
further thing. I did speak with counsel. It's attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, well, with respect to our general arguments, we'll just rest on what I'll rest on what I said previously, and we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that on that morning, he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert? All right, and counsel on behalf of, oh, that doesn't concern you. Okay. All right. Thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right, we're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pre-trial non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is
No,
what the,
I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
all right, and you can't be here next week.
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is if you're not here and you have to be here
that's
for
why we
that.
did.
So
That's why we did that, so.
Ms. Yannetti will, I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. I'm not asking for any action on it, but I believe that would be it.
Okay, and I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes. On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday.
Sure.
Where we are with that. All right, great. I'll see everyone Tuesday. Thank you.
Your Honor.
Thank you, Your Honor.
March 26, 9 a.m. hearing on all pretrial non-evidentiary motions.
All right. Brian? All right, Brian, we have a 3 o'clock list.
I'll come in and raise them.
Okay, thank you.
You are muted.
No, the Duarte one, attorney can't, she asked for Zoom, but now she can't do it. So we're in good shape.
Goodbye.
Okay, guys, thanks for being here. Please do us a kindness and hit subscribe so we can hit, for us, the holy number of 5,000 subscribers. It's a very modest number, but please, whether you agree with my opinions or not, just be a little bit generous and do that for us. Now, let's go over what we heard today. I am going to look at notes that I took here and comment on them. I'm not an attorney, just a regular guy giving you guys my opinions. All right, so let me just make sure them. All right, everything's hooked up. All right, so today, Proctor, the first we begin on the Rule 17, Proctor does not object to making the internal affairs information available. And it sounds like whatever they've already generated has already been provided. and that whatever ongoing materials that investigation generates will be turned over immediately. So it doesn't sound like that's a major issue here. So there were a lot of other interesting things that came out, though. Trying to read my terrible handwriting. So we heard a lot about we heard from Brian Albert and Brian Higgins attorneys, and about communications between them, and also between them and Berkowitz. So Yannetti, one of the early discussion, Yannetti was trying to say that the Canton police were conflicted out. And that means that there was a conflict of interest, and that's why they were not covering this case. The judge asked for evidence of that, and Yannetti didn't have it, but he said he would provide it. I don't really understand exactly what it means, because my understanding, and this is, I think, what the judge made clear too, was that in Massachusetts, there were 3 cities that are big enough to have a homicide department, and that would be Worcester, Boston, and Springfield. In every other town or city or village or hamlet, if there is a suspicious death like this, it automatically goes over to the state police. So every one of those Canton cops on the scene that morning, before John was even loaded onto the ambulance. Now, John was alive, but is barely alive, and his body temperature was 82. So I think most of them expected that he wouldn't make it. And it looked probably like a hit and run, possibly in a fight. Who knows what they were thinking at that moment, but they knew that the state police were going to be taking over this investigation. So it's kind of interesting what this evidence will be on the Canton police being conflicted out. I don't really know when did that happen, because by the time the state police were involved, the Canton police weren't doing anything. The only things that the Canton police involvement was in the early hours before the state police got there, and their involvement was minimal because they knew the state police were coming. So the situation was, there was where John had been taken from in the middle of a blizzard, and the snow was really piling up. So they knew that some of the evidence that was there was perishable. So famously, they took some blood drops that they found in the snow, and they collected it in cups, because they knew if they didn't, that evidence would be destroyed. It'd be gone forever. So, why did they do that? It seems to me they did it because they thought at that moment that maybe that blood belonged to someone else. They weren't looking for John's blood. You can get plenty of John's blood inside his body. So for identification purposes, you're seeing if it's someone else's blood. But they didn't do much else more than that. They did find the cocktail pieces, because where John was found on the lawn, about 12 feet from the road, it hadn't snowed that much yet, though it was snowing heavy at that time. I think maybe there was a couple inches by then. And John, because of where John was lying, his body temperature kept the snow from accumulating there. And because of that, he was lying on grass. And that's where the cocktail pieces were found. So presumably the cocktail glass was in his hand when he was struck. And that's why the glass flew with him. That's just physics. You got something in your hand, and you get launched by a vehicle. That glass gets the same physical that gains Newton laws of motion. It's going to get that same motion put on that glass because it was in your hand. So even if you let go of the glass in midair, it's going to mostly go with you because it's got the same momentum on it. They did not find any pieces of taillight, which was something that Turtle Boy found to be the key piece of evidence for him. Why wouldn't the Canton police find that taillight? And that is an important question. For me, I had settled that by the end of the summer by realizing that those taillight pieces, and really it was one hand-sized piece, was found inside a plowed snowbank. Now, it was not a big snowbank, all right? Only a couple inches had fallen by then, but there had to be a snowbank there, if Lucky's telling the truth about that, because Lucky plowed at, right, not sure exactly what time, maybe around 4:30, right? So, but he had plowed there. So a plow had gone down that street. So that would have scooped up the small pieces of taillight and the hand side piece and left it inside a plowed mound, on top of which would be another, inch or so of fresh snow. And there's no way the Canton police were ever going to take a shovel to that crime scene that they knew the state police would be taken over, and experts that are trained in that kind of evidence collection would be taken over. So they just weren't going to do that. So they just kind of did what they could to save what the perishable evidence. All right. So Chief Berkowitz is someone that's played a prominent role in both the conspiracy theory of this case and in events, and some things that actually are proven. So I believe at the time he was out on leave, but he would know the area very well. Across the street from Brian Albert lived Deputy Chief Kelleher, and there are other cops that live within a couple of blocks of this too. There are a lot of cops that live in that area. So Berkowitz would know that area very well. And obviously he knew Brian Albert very well, because later on he tried to protect Brian Albert, preventing his name from getting out according to a reporter that was tweeting that Brian Albert lived there a few days later. And Chief Berkowitz interfered to say, look, can you please not put his name out here? He's a pillar of the community. So there's no question Berkowitz was, involved in events here. I'm not sure, I think it was 6 days later, was driving by, and you heard Unetti mention it, how he found a piece of some small pieces of taillight. Of course, you have to remember, this was one of probably the biggest blizzard in that area in the last 10 years. And then we had several warm days after that. So we had kind of a January thaw. So as snow melted, more pieces of taillight were getting revealed. So is it unusual that he drove by and spotted that? People can decide. But to me, with evidence like that, I look at it and I say, maybe it's unusual, maybe it's not, right? And this is where I talk about the defense theory of what I call the defense strategy of odd things. And this is something that every defense is going to employ. The first thing you do, you go in there and you're going to, now let's just assume that 90% of the people that actually get indicted generally in court cases are guilty. I don't know what the actual number is. I'm throwing that number out there. And 10% are people that are indicted and charged, but are innocent. Now, maybe it's more like 95%, maybe it's 88%. I don't know. But the vast majority of people that are charged in criminal cases are in fact guilty. But in every one of those cases, it's the job of the defense to create reasonable doubt. And that process begins by looking at the vast material that they get through discovery about the investigation and identifying odd things. And there will always be, in every investigation, odd things that they can identify, because an investigation involves numerous people, numerous teams, and each with their own things that they're good at and things that they're not good at. All investigations involve human beings. Human beings are flawed. So I've never looked at any investigation, when you start looking into it deeply, that doesn't have this stuff. And we're seeing another case that I follow very closely is the Delphi murders. And the defense just put out a motion last week, and I went over it on the air a couple nights ago. It's a little boring going over that stuff for you guys, but I thought it was important for you to see. Then it goes on there too, that even though there's overwhelming evidence against Richard Allen, and he in fact confessed in jail, which is admissible, to killing Abby and Libby. He confessed to his wife over the prison phone. There's still, they're able to almost, if you take the defense, I don't want to say trickery, but they're going to highlight things and make them look in a certain light all the time. Now that, of course, it's important that they do that, because there are cases where people are falsely accused. So odd things like that can mean that the investigation was more than just flawed, that it was corrupted, right? So I'm not dismissing odd things as important. They're very important, but you have to always weigh it. So if the evidence against the defendant is very, very strong, then odd things are just odd things, because they're in every case. If the defense is not so strong, then you have to look at those odd things and look closely at them and see, okay, is there something going on here? So Berkowitz finding taillight pieces 6 days later when the snow was melting, it's one of those odd things, right? Is it odd? Is it not odd? It's hard to weigh it. But if you start to think that if we determine that the evidence against Karen is not so strong, then things like that become much more relevant. And this is really what this whole strategy was here today, was to talk about communications between Brian Brian Higgins, everybody's Brian in this case, or almost everybody. So between Brian Higgins, Brian Albert, and Chief Berkowitz. Okay. Now, a lot of emphasis was put on the fact that Brian Albert and Brian Higgins initially did not report that they spoke at 2:22 in the morning. So Brian Albert called Brian Higgins. Higgins didn't answer the phone, but quickly called him back. And so there's the aha, right? Were they plotting the conspiracy at that time, right? Was Brian Albert saying, okay, this is how we make the next move? What was that? Something really suspicious? Was it suspicious that they didn't initially testify that? Is that lying, right? Or is it just false memory? I mean, it's really hard to tell, right? But the thing was, the call. So when Brian Higgins called Brian Albert back, the call was only 22 seconds. I mean, that's an extremely short call. How much conspiracy plotting can go on in 22 seconds? Now, I'm not dismissing it. Again, if you're looking at a piece of evidence in isolation, had they already, for instance, plotted the conspiracy before Brian Higgins left the house, then Brian Albert could have, in theory, been calling to say, don't forget to do this, right? That's how, so it could work that way. But it's, how much plotting could actually go on in 22 seconds. So you really have to take a look at this, an objective look, and a both sides kind of look. Now, you could also get a little sense here. I'm going to talk about this, try to talk about it fairly. So according to what these guys found, this is all right, so I guess it was in Brian's second testimony before a grand jury. Yannetti didn't make clear if Brian Albert testified twice before the state grand jury and then to the feds, or if by the second testimony he means the time that he went before the feds. Probably the latter. So the time that that second testimony, he now, instead of saying he butt dialed, said something about he was basically having sex with his wife. But what you can also take from that is, this is why people lie when it's not part of a conspiracy, right? People have embarrassing things on their phone and in their messages that have nothing to do with the conspiracy. So you just don't know, right? I mean, we don't know is Brian Albert telling the truth on the sex thing? I mean, is he making that up? Why would he make that up? I mean, couldn't there be something better to make up? But if that is true, what else do people do? And again, I'm not accusing, I don't know anything about these guys, right? But a lot of strange things go on when it comes to sexual stuff. We see, I don't focus on this thing, but when you look at, for instance, Aiden's taking video of all the girls, all the women that he's with. He's having affairs all over the place on his wife, and he's always video recording it. Now, part of that is for the practical reason of he knows there are no sextortion laws in Massachusetts, so he's going to use that to control them later on. But I would guess that part of it is he gets off on that, looking at him later. It's something he enjoys. And also the person that's involved with a domestic violence, I think the violence part has been dismissed, but let's say a witness and someone that he had been dating and that is now charged with witness intimidation against, that she also had been filming their sexual escapades and sending photos and I think video to him. So a lot of this goes on, right? So, but then later on it becomes embarrassing. So was there something like that going on? And so the messages to Brian Higgins were just kind of a boys being boys thing. We don't know. So the judge has to decide whether that stuff is relevant. I mean, I just think it's probably best to us to not jump to conclusions on messages like that too quickly, but just understand that human behavior is complicated, and so that could be something that would make somebody want to hide their phones. But now, all of these guys, their lawyers got up today and essentially said, we'll comply with any orders on the phone material. Some of them said they opposed it, but really at the end of the day, they were all saying the same thing: is that we think this is a fishing expedition, and we're not going to fight. We're not going to fight the judge or the system if they want that material. So, interestingly, David Yannetti is saying that the feds have that material. And so this is the scary thing about the feds, why, but they didn't turn it over in that stash. So why would the feds, sorry, I dropped my pen and it bounced somewhere impossible to find. Oh, there it is. Why would the feds not turn over that messaging, yet other messaging they did turn over? So, I mean, there's a lot of stuff. There's a lot of aspect. Now, maybe they're protecting people. I don't know. But why would they? But if they thought it was relevant enough to get that information, why didn't they turn it over? I also, I'm told that a lot of the thing with the feds is, now we think that normally that for a prosecution branch of the government, which is both district attorney's office, and that's the state, and then also the federal level would be the U.S. attorney's office, that in order for them to get our phone records, they need a warrant. And while that technically there is a truth to that, in order to force someone to give over those records, yes, they need a warrant approved by a judge. However, I'm told that when it comes to the feds, there is kind of a system going on here where if they ask for the records nicely from the phone company providers, the phone company providers just give it over. So no warrant is actually required, which is it's kind of troubling, isn't it? I mean, the idea that the feds, if they want to look into somebody, they can just request stuff from the phone companies or from Google or whatever, and these guys just give it over. We understand why, because they're terrified of the feds. The feds have enormous power over them. And so to me, I find that really troubling. And I think, I have a very small channel, but I think it's something we should be upset about. And that's something that someone in Congress should be making us think about. Like, no, you shouldn't be doing that. You shouldn't just be able to go and grab whatever messages from people you want. But it sounds like that's the case. They're able to do that because all these companies comply because they're afraid. So the feds have any records relevant to this case, any communications relevant to this case that they want, that they could get, if they could be got from the phone companies or from Google or from anybody or Facebook or whatever messaging was used. These big companies comply. So whatever they had, they turned over to the feds. And so let's just say that right there. The feds have everything, A. B, for some reason, they haven't given all of this over to the parties for reasons we can't fathom. C, there is no question, whatever you think happened in this case, or I think happened in this case, there's no question that there's a lot at stake for Josh Levy. Okay, this is now the U.S. attorney. And he was first U.S. attorney at the time, so he was right under Rachel Rollins. It's a very powerful position. He left an elite law firm, which he was a partner in, called Ropes and Gray, in 2020, just in 2020, to take this job. So there had to be some ambition involved. Either he wants to be the U.S. Attorney General, which is a cabinet level position someday, or he wants to be a judge. For whatever reason, he got involved in this case. And we do know that it was initiated by Karen and her lawyers. It wasn't like they picked up some strange wiretap or something like that, or some informant came forward. And clearly now, also we saw today, there's no chance that Higgins has flipped. Higgins has never, he's cooperated in every way, and he's not a target of the investigation. He certainly hasn't been indicted. So Higgins never flipped. Higgins doesn't know anything relevant to any kind of a conspiracy, so he's just never had any reason to not cooperate. And that's done. So that's just one of the false things that people have been reporting for 7 or 8 months, and it's time to just let that go. But if the feds have, I'm back to this. So 3, Josh Levy has a tremendous incentive now to make sure that he has an incentive to find a conspiracy here, to find a cover-up. And the incentive, and the reason is because it looks really bad on him if he got duped by a defense team, maybe because he knew them or had some personal connection, or we don't know what the reason is, right? But even just if they duped him, like they walked into his office and for some reason they're able to convince him of something. If it turns out whatever they convinced him of is not true, then he looks really bad, and he knows this. So whatever ambition he had of being attorney general at the cabinet level, or of being maybe a state attorney general, or being a judge, if they don't find a conspiracy here, that's out the door. And maybe worse, because depending on what else went on, if any of those communications between Josh Levy and Karen's defense team, which seemed to have been a regular thing, if any of that stuff was improper, there could be problems there. And so you'll have a federal investigation of that. And we know the state's digging hard at it. So he has every reason. He has as much reason as Turtle Boy to find that there's a cover-up. So he's leaving no stone unturned. That means he has absolutely got every communication that might potentially, because there was no limit. Like they're the feds. They can just ask for communications. They could be asking for mine right now and saying, well, maybe the state's been leaking discovery material to this little YouTube podcaster, right? They're not. But they could be looking that up, right? They can get whatever they want. So the fact that they can get whatever they want and they did not discover a cover-up is pretty compelling, I think, But there was a lot of interesting stuff here. So let's go through, let's see. Yeah, so Higgins, for my notes, Higgins' lawyer says he spoke to the U.S. attorney, and Higgins has not been indicted and has not been given a target letter. If you're the subject of a criminal investigation with a federal grand jury, you get a target letter, and he has not been. He's still working for the federal government as an ATF agent. All right. Lally, in his rebuttal, says that all of the stuff put together by the defense is unsubstantiated conjecture that is contradicted actually by other parts of the federal grand jury. So we don't, and he says it's a fishing expedition. So, we don't really know, right? The judge, they ran into an interesting kind of dilemma where the judge had ordered all the relevant materials to be released to the lawyers of the people whose phones are being requested by the defense, whose phone records are being requested. And Lally had not complied, but not out of any wrongdoing, but he thought the protective order regarding the federal material prevented him from doing that. So Judge Canone was not at all, I don't think she was mad at Lally, but she was very frustrated that stuff had not been turned over. But it didn't end up being a barrier, because the lawyers for the Brian Higgins, Kevin Albert, and Brian Albert they didn't stand in the way. That was important. They made their arguments, and they said, we're going to look at the materials after, and if we have something else we want to file, we'll file it in a motion. But for now, we'll just say we're not even, we're going to oppose the idea of the phones being released, but we're not going to in any way try to fight in order to do that. So they're really not opposing it. So Higgins, Brian. So also, Brian Albert was told by the U.S. attorney that he is not a target. Neither are his wife or his kids. So it's really hard to imagine that the feds found any kind of cover-up or conspiracy involving Brian Albert, because he would be a target. He's not. So that's straight from the U.S. attorney's lips. Then a lawyer named Connolly, I think, got up and spoke to he was representing Brian Higgins. He said that Brian has cooperated fully with both the state and the feds. He got his subpoena last April. He also has confirmed that he is not a target. And his lawyer wanted to emphasize that he has not participated in any cover-up. Well, naturally, his lawyer has to say that. But the fact that he is not targeted, there's not. Let's say Higgins had flipped, then there would be a deal worked out. There'd be basically an indictment still of Higgins. He would be indicted, but then he would get generous terms because he'd flipped. You've seen enough mafia shows to know that's how it works, right? So none of that is none of that's on the table. And again, he said he will not give up his phone unless ordered, essentially. But they're all had different ways of saying the same thing. Like they're not going to fight it if it's ordered. So then Kevin Albert's lawyer. Now, Kevin Albert is Brian's brother. He's a detective on the Canton Police Force. And my understanding, what I'm told, is that Kevin, of all the people that were friendly with Brian Higgins, it's Kevin who had been friendly the longest and the most. Brian Albert's friendship with him had been maybe less than a year, but they had obviously were drinking together, so they were becoming friends, but that the longest standing relationship was between Kevin Higgins, which makes sense actually, because Brian Higgins, ATF agent, had an office at the Canton Police Department, and Kevin Albert is a detective on the Canton Police Department, so they're working in the same building. So it's not surprising that they met and became friends. And at some point, maybe it's a little bit also not surprising that over the last year, the year previous to this, that Brian Albert and Higgins were becoming more chummy because they seem to both like to party. And you have to realize that a lot of these communications were probably about that. So again, Brian Albert called Brian Higgins at 2:25, and then Higgins called him back, and it was a 22-second call. Both of them seemed to try to initially want to avoid confirmation of that call, whether they didn't forget it. Whether they didn't remember it, which, both these guys have been drinking for a long time, and the call was only 22 seconds. So it's very possible that they didn't really remember what had happened with a meaningless call. Or there could have been something embarrassing that they really didn't think they didn't want anybody to know about, But in any case, Brian Higgins immediately volunteered all of his information to the state as part of their investigation. And he's cooperated with the feds, and he's testified before both grand juries. Unetti complained that the state did not ask Brian Higgins about that call, but the state didn't know about it. That call was only revealed because of the feds. Now, I don't think that call is probably relevant to anything, but you never know, right? But there's no reason the state would have investigated something that they didn't know existed. So over the next several days, according to Unetti and according to what they found in the feds, that Brian Higgins interacted, that's the word he used, interacted with Berkowitz and Brian Albert. And I think also Kevin Albert. Can't read my own notes on this. This was in the days after John was found. So again, is that really unusual? I mean, if somebody that I had been drinking with earlier in the night was found outside on my lawn, I might tend to talk to my friends about it. And I might tend to talk to the people that were drinking with me that night, which was the case with Brian Higgins anyways, not with Berkowitz though, and not with Kevin. All right, so Josh Levy I guess really laid into Brian Higgins when it came to his communications, his calls with Chief Berkowitz. My understanding had been for a while with this that Chief Berkowitz was pretty close to Higgins. Again, Higgins had an office there, and he's a Fed. But Levy really hammered in the federal grand jury the calls between Berkowitz, Brian Higgins, and Brian Albert. Again, but that doesn't mean that he found anything. The feds have all those communications, and Levy is desperate to find something here. He's got a lot at stake. And then Berkowitz spotted that tail light. Yeah. So, he brought that up again. I also just had a note here. At this particular moment, I was watching Karen in court, and I've been trying to interpret a little bit. I try not to, I don't try not to get in somebody's head, but when she has looked extremely confident in court over the last several hearings, and I would say certainly one thing that indicates is I don't think she's planning on trying to work out a plea. If her strategy was to work out a plea, now who knows, maybe Yannetti in his back of his mind is thinking we need to get a plea, but I don't think Karen's thinking that, because that plea would involve her going to jail for presumably they would get it down to manslaughter, and she would go to jail for, I don't know what, maybe a year or something. Right. So whatever there's evidence that both these sides have, because they're in discovery, that we don't know about, a lot of evidence. And so we're left to speculate on what that evidence is. But whatever that evidence is, it's not smoking gun enough that Karen, at least in her own mind, thinks that it makes sense to plea. So we don't know what other stuff is there. There's, for some reason, the grand jury, the state's grand jury, upped the charges to second degree. Was that just based on her saying at the scene, I hit him, or second degree implies malicious intent? So does that mean that just the fact that Karen and John were arguing, that's the reason? I that seems weak to me, but then again, the grand jury only has to decide whether or not there's probable cause. So the grand jury is not saying that Karen Degree is guilty of second degree murder. They're saying that there's probable cause for a trial in order to decide whether or not she's guilty of that. So, but there are other possible things that would indicate consciousness of guilt, such as if she turned her GPS off that morning. Now, we have powerful indications that her GPS was turned off, but we don't know when. Did she turn it off the week before for some mysterious reason and forgot to turn it back on? But there are indications they don't say it, but there are pretty strong indications both in defense and prosecution documents that her GPS was off. Maybe the chip was malfunctioning, right? I don't know, but it definitely seems to have been off. Now, if we find that it was turned off sometime between, say, 1 and 5 a.m., that would indicate consciousness of guilt. There's also the Ring videos that are missing. Is it shown that she deleted that? I don't know. If those things were shown, would she look so confident in court, though? Maybe not. So maybe those things aren't really established. Then Lally get up. Oh, let's see. One more thing, friend. Yeah. Just my notes here was, why don't the feds? I don't really understand why the feds have not given over all these phone records, especially since they were relevant. So if Josh Levy himself is doing the questioning of Brian Higgins, and according to Yannetti, is hammering him about communications between him and Kevin Albert, him and Brian Albert, and him and Chief Berkowitz. If he's hammering them, and the feds have all those communications, so they have the communications of Berkowitz and Higgins and Albert, Kevin and Brian. If they have all that, why didn't they turn them all over? I find it really strange. I'm tempted to say here it's because they're inculpatory. I mean, because the feds, they're acting really as part of Karen's team now. They have an interest now in this case. Just like, say, at this point, you might say Morrissey has an interest in finding that Karen is guilty, and that would be reasonable that his office is now in that position. But it's also just as reasonable to say the feds have a reason for finding that there's a cover up here. So maybe they didn't turn over records because they were inculpatory. They showed, for instance, they would be inculpatory if those records show that there was not enough communications to be the basis for a cover up. or there was something in those communications that would be inculpatory. So Lally did not oppose the phone motions. So this is interesting to me because it's clear that the judge is determined to keep this trial on track, and this is on schedule. And this is why she was so frustrated when I've never seen her that frustrated. She was really frustrated when she found out that Lally had not turned over the relevant federal materials to the attorneys for Higgins and Brian Albert and Kevin Albert. And the reason she was that frustrated is because she knows in her mind she is not going to rule on the motion to dismiss. She's not going to rule in favor of the motion to dismiss. And she doesn't want anything to upset the timeline of this trial. So she didn't want to have to reschedule this hearing or something like that to come back because those attorneys didn't have a chance to see it. And I think sensing that's why the attorneys maybe didn't fight it so hard too. But and also because they're probably innocent and there's nothing in there to fight. But so Lally's not opposing these phone messages, phone records. I'm sorry, he's not opposing this. So it's pretty likely that the judge is going to allow it, but I don't know what she's going to allow. I would suggest that she'll allow the feds. I don't know. Maybe she'll can't compel the feds. Maybe she will ask the feds to turn over what they have on those records to both parties. But if they have to go to the phone company and get them, that's going to delay this trial by months, which is something the defense clearly wants. But I don't know. So I don't know. I know she doesn't want to do that. She wants this thing to go forth on schedule. So, but if she allows the ordering of those phone records from the phone companies, and I don't see how she could, if she asks the feds to give over what they have and they get back and they say, we don't have those phone records, can she still then deny the ordering the phone companies? Because if she found it important enough to ask the feds for them, then it seems like it would be important enough to subpoena the records from the phone companies, which will delay this trial. Yannetti has another motion or adding to their motion to dismiss next week. So there'll be another hearing on this. Goody, right? Also, Brian Higgins' lawyer revealed that he early on, probably after he got subpoenaed by the feds, went and spoke to the U.S. Attorney's Office. So I think this was before he appeared before the federal grand jury. And he told them that he had spoke to Brian Albert and Berkowitz in those days. So he was very upfront with things, according to his lawyer. Lally also revealed that some of the labs have still not been completed. So I'm assuming that is related to the DNA. All right. So let me get to, thank you for bearing with me. Please hit subscribe. I would very much appreciate it. And Mark Sweeney, I think you've subscribed if you're still here, even though you completely disagree with everything I say. So let me get to the comments. And just so you guys know, I have not been following the comments over the last half hour or whatever. So whatever you guys have been saying, I haven't seen. So please ask any questions now that you think I may have missed, because I have not seen them. And Kathy Chapin joined up a membership. Thank you. I appreciate it. I don't know what you get with that. You have to set your channel up when it's monetized as a member. These membership things, I set it as low as could be allowed, because I don't have anything special things that at this point that we offer for like paid subscribers. So you're basically just supporting the channel. What was it, $1.99 or something? Thank you. I appreciate it. Much appreciated. So Nathan says Kevin could never answer. Maybe you can. I'm not sure if you're talking about Kevin Higgins. Kevin Albert or me, but now is the time to ask. It looks like they were talking about the cocktail glass. So yeah, John left the bar with an unfinished drink, drank it on the way, and the broken cocktail glass was found around John's body in the grass. All right, I'll scroll up a little, Nathan. Sorry, brother. And not only was the glass found, but the straw was found. So this was another thing that I had noticed a long time ago. So if the conspirators had attacked John inside the house and then took the broken pieces and dumped them in the lawn, they also had they were so thorough that they even took the black straw from the bar and put that with it. That seemed a little bit unlikely to me, but who knows, right? So I guess the question was about what part of John's body hit the taillight and broke it. So yeah, I mean, these are questions that have to be answered, and I believe at this point, what makes most sense is probably the cocktail glass. We'll show Frank's question. Frank appreciates people trying to be objective, so we really, believe it or not, we try here, even though I have opinions that formed over a lengthy time of looking at the evidence. I'm still objective, and I'm not on anybody's side. So Frank says, but if the feds say they do not have the records, both the defense and Levy would have egg on their faces because Jackson and Yannetti have pounded this federal grand jury as an aha. Yeah, I mean, it's so they're going to take, this is what the defense chief job is. They're going to take little bits and pieces of everything that's in there and try to highlight on it, put a spotlight on them and spin them. That's them doing their job. That's what they get paid the big bucks for. Judy asked if I'm going to mention what's going on with Sean and Turtle Boy. So they kissed and made up. I mean, I don't know the inside of. We just know that they were fighting pretty bad, and Sean was accusing. I mean, Turtle Boy was accusing Sean of being wrong on everything, which is actually true. Pretty much. I mean, even him talking about Higgins flipping and indictments coming. I mean, at some point, it's just like, all right, everything has been wrong. Predictions to key pieces of evidence reported. So Turtle Boy's correct on that. Sean has accused Turtle Boy of being a rat, that they flipped him in jail and he's working for the state. So that's where the battle is. Turtle Boy posted a couple of days ago that he called Sean and they worked the difference out, and that Turtle Boy is going on Sean's show Sunday night at 7:30. So yeah, I will watch, and we'll see what they do. Are they going to battle, or are they going to try to present a united front? So we'll see. It should be interesting. Just to repeat. Oh, take the court. Yeah. Thank you. Good idea. Good idea. Take the sometimes you're so busy watching, you forget. Thank you, Slatherings. Good to have you as always. So Nathan said, so you believe she hit him so hard he ended up in the yard, and then also has glass launched there too? 100%. 100%. Because if you have that glass in your hand and you're launched there, anything you had in your hand is the same momentum goes onto that object, and it goes with you, even if you let it out in the middle of the air. So if I've got this pen in my hand and a 2-ton vehicle smashes me hard enough to launch me into the air, and I saw a motorcycle driver apparently launched about 20 feet in the air yesterday coming home from the gym. I didn't witness him getting struck, but I got there a couple minutes later, and he was lying in some bushes about 20 feet from where his bike was crumpled in front of an SUV. And on that road, the vehicle couldn't have been going faster, I wouldn't think, than 30 miles an hour. But still, when it slid into that SUV, it launched him 20 feet. So there's a lot of force involved in these things. And if you're holding an object like this pen and I get struck by something hard enough to launch me 20 feet, that pen goes with me. And even if I let go halfway there, that pen has the exact same momentum as my body does. So it's going to end up with me. ABG says, could I be a little more boring? Yeah, probably. I could probably do that. But the thing is I'm not an entertainer. I'm not here to entertain you, as they said in Gladiator, right? And also trying to just discuss things from both sides instead of screaming at people and calling them up on the phone and starting fights is generally boring, right? But this is the kind of people that we have here, is we want to just look over things objectively. Okay, so I'm going to make an executive decision and put him in timeout, because the thing is, he's saying only idiots believe Karen is guilty. The overwhelming majority of the evidence says that Karen is guilty. Now, that doesn't mean that might not turn out to be wrong. But this is a kind of conspiracy that from the start, any sensible person says it's extremely unlikely. Now, unlikely conspiracies do happen, right? But that doesn't mean you should start from saying, all right, this is unlikely because it involves so many people that would have to be quiet, the 11 people in the house, and it requires so many investigators and officials involved at some level of either looking the other way or planting evidence. Those kind of conspiracies are extremely unlikely, and there isn't incentive for any of those people to. So if you're risking going to jail for something, so let's say you're Michael Proctor, you're going to plant evidence 16 hours after John was struck. It's extremely risky. The more time that goes by, all you have to do is, if any video or image that shows up in that 15, 16 hours that shows Karen's taillight intact, he's going to jail for decades, right? Because he's now participated in a murder cover-up. So that is extremely unlikely, and that should be your default position. Now, as people start to file on, as the defense starts to pile on evidence in April and May with their third-party culprit theory, that maybe you start to say, something strange happened here. But the only sensible position to start with would be that this conspiracy was extremely unlikely. And that's just a sensible position. And so to go on and say that anybody who thinks Karen might have done this is an idiot, that puts you into zombie territory to me. You're just not really bright enough to be here. So I'm going to put you in timeout. And if you want to go and have an injection into your brain that'll wake it up, then you can come back. Just looking through the comments. Hey, we have our friend from Norway here. That's an awful long way. Let's put his comment in. He's in a very different time zone. Oh, this was at 3:38. So it was 6-7 minutes ago. That's not too bad. I keep falling back on why so much secrecy in relation to the investigation by the feds and what was found there. Wouldn't the feds come out in plain text and say that Karen didn't do it? No, I would say that that's complicated, because a federal grand jury is very secret, and we have dual sovereignty here. So the state is running a murder investigation. It's very unusual for the Fed to be running an investigation that really kind of interferes with it. So it's very, very interesting. I'm not so sure that it's complicated to figure out how they would reveal what they found. But at this point, they've turned everything over. Slathering says 23 miles an hour would knock you down pretty good. Yeah, it would launch you. It's because of the weight of the SUV. Nathan said so much force and only her taillight broke. Yeah, because it was kind of a glancing blow. And also the vehicle is hitting a soft target, right? And a lot of when you look at hit and run, a lot of times, or more normally, the victim bounces up onto the hood, so you get a dent in the hood. But that didn't happen here. It was because the SUV is a tall vehicle, and so it hit some center of body mass and just sent at an angle. So it sent him off at an angle. All right, Sally, I don't even know who you're calling pigs, but it's just stupid. So I'm getting rid of you. Whether you're supporting my comments or not, I don't want you in there just repeating pigs. It's just stupid. We're trying to have a boring but intelligent discussion here. Okay, so just let's keep it civil. Don't make me get Tom Fleming after you. Brian asks, how important will the how long to die in the cold search be at trial? He says that I think it will come down to which expert the jury believes. We'll put his comment up. All right. So I don't think that they're going to I predict, and have long predicted, that the defense is not going to bring this up at trial. I know that sounds strange, right? It seems like a great way to bring up reasonable doubt. But you have to understand it's going to be different with a jury. Now, I'm not talking about someone that may have gets on the jury that's been impacted what they've already read about this case, and the selection process will try to weed that out. But if you have somebody that's neutral and hasn't followed this case closely, which, believe it or not, most people in this state have not, they're going to be on the jury, and they're going to start out, like most of us do, with the expectation that 90% of cases that are prosecuted involve someone that's guilty, and that in every one of those cases, the defense team their job is to create doubt. So they're going to be kind of skeptical from the start about the credibility of the defense lawyers. And it's the job of those defense lawyers to overcome that skepticism and win over the jury. And so if on any single issue, see, we think that what the defense team will do is just throw a bunch of stuff out there, hoping that something sticks. And if it does, it creates reasonable doubt. But that's not the way it actually is. Because if they're throwing out a lot of stuff that turns out to be bullshit, then what happens is the jury starts to tune them out on everything. So if you have Jen McCabe testify, and probably over a couple of days, because she was a key witness in so many aspects of this case, she's going to testify no matter what. And you bring this woman up and she's a soccer mom, and she's never committed any crimes, and you're going to try to portray her as this Lex Luthor orchestrating this crime that involves killing her friend. It just doesn't seem it doesn't seem likely that the defense team will want to go there. So I don't think that the defense team is going to bring up 227. People have been asking me over the last couple of days, is there some kind of new Google report that shows once and for all that 227 search never happened? I don't know. I'm hearing that, but I don't know what that is, and I can't confirm it in any way. And I have not heard that from any official sources, so I don't know. I do know appearances are that I do know that the witnesses are very comfortable that the evidence is solid in their favor and that the 227 thing will go away. That's all I know. I mean, keep in mind that the prosecution has the guy who wrote the software that they all used that supposedly found this 227. It's a program called Celebrate, and the guy, it's from a European company that does that, and the guy who wrote that software, or who oversaw the creation of that software, is going to testify for the prosecution that timestamp is inaccurate. Scott is sticking up for the people we put in timeout, which I've only put 2 in. I don't know how many Tom has. Says no timeout. It's super interesting hearing people's thoughts. Just to make sure you understand, Scott. Yeah, I mean, I think you've been here enough to know we welcome people that argue with us. This is not about taking anybody's side here. I want to always both sides things. So people that come in and state their opinion, they're welcome. But if you start screaming in caps and insulting people, then that's going to go. Or if you start saying, I have no use for that. We wanted to have a good discussion here, and we want to all learn from this. Maybe we'll take on another case. So, for instance, we do a lot of work on the Delphi case, and you see a lot of this there too, and that trial is now scheduled for May, and that's a bigger case globally with terms of interest than the Karen Reed case. But it, you know, and also one of the things that we want to focus on is, let me just share this real quick. Share the screen real quick in case you guys. So this is a case we want to cover more closely because these girls were abducted and killed in 2012 in Evansdale, Iowa. And it's unsolved, but there are a lot of suspects and there are a lot of clues. This article here, in case anybody's looking for it, and you can always email me if you want me to give it, it will send you the link. But this is on a site called The Unsolved, and it's a really detailed article. But I think if there's a case to where we could possibly look into something and develop an insight, this would be it. You know, I'm not saying that we can solve it. None of us are professional investigators and stuff like that. But even just helping to bring attention to the case. I mean, look at these poor girls. And when I started looking at this too, it turns out that in that, I don't want to say in that local area, but in that geographic area. So within say 100 miles of where they were killed, there were numerous failed abduction attempts, mostly on girls the same age in that same period of weeks. And some of them involved accomplices. And in one case, it involved a male and female accomplice. So what is going on down there? Or is that maybe that stuff goes on all the time and we're just noting it here? I don't know. But I think it's something that we could look into. So if you guys are interested in, well, I'm going to be looking at this with Dave McGrath and also Bill Noguera, who is, I know this is controversial with some people here, but he's a guy that spent 40 years on death row. He's now serving a life sentence. He committed murder when he was 18, but he's got an incredibly sharp mind. He's looking into this case for me. I talked about it with him yesterday, and he already has, he absorbed up the details of this case already has very common sense, logical insights onto it. So I think all of us together, we can maybe develop some insights, and it's worth pursuing. So let's see what's happening. Let's always take a logical approach to these things, you know, and a both sides approach to every piece of evidence. I personally think that's important, you know. So people that want to come in here and have different opinions on any particular piece of evidence, that's welcome. I mean, that's needed. We always want it. And many good voices on any particular subject, the better. But now to come in and just start throwing things around and acting stupid, it's not worth it. So just, I think I already answered that. Hopefully the question from Brian again about how long to die in the cold, you know, I don't think it's going to be a factor at all. At case scenario though, we don't know what, you know, Alan Jackson was slippery in the words about what exactly the FBI and Quantico found. Like, why did he throw in the Quantico word? That's just to try to dress it up a little bit. So did the actual department that does, at no time did he mention forensic experts from the FBI, but we'll see, right? So what exactly is in that report? But they're going up against the guy who wrote the software. So that's, at best, you might get a wash out of that, where the jury sits there and said, all right, we got experts on both sides, including Jessica Hyde on the prosecution, who's one of the most esteemed in the world. And then the FBI, obviously, there's, if it actually does turn out to be forensic data experts from the FBI, they're certainly very esteemed and in the top and as good as anybody in the world. But the jury's going to look at that and say it's a wash. Then we can't really make sense of it. But you know, it should be a fascinating cross-examination if the defense attempts it, because we'll get the defense. We'll get the prosecution being able to question this FBI expert, if he's an expert, and say, what do you think about Ian Whiffin's explanation? And he's the guy that wrote the software. So that should be really, really interesting. Neil Chauvin says the investigation is ongoing. It's much deeper than this case. Well, all of us have been wondering that since this summer. But according to Yannetti, this case is just this case, that the investigation was launched solely to look into the Karen Reed case. So, yeah, the Birchmore case is fascinating. We've done shows on it. and it's important. And it may involve some similar issues or maybe not, who knows, right? But doesn't seem to be any connection. Kerry points out that that the FBI said the Alberts and the Higgins are not the targets. Well, it was the U.S. attorneys that said that, but yeah, that they're not the targets. Slathering says, and cars are strong. Taillights are apparently their only weakness. Actually, I did some research into this, and cars are designed to collapse because if they didn't collapse, in fact, up until the 1950s, they were designed much stronger. And the reason they're designed, the front end of a car is designed to collapse in an organized way, is to protect the driver, the passengers. Because you think about it, you have a soft-bodied living person inside a vehicle and it smashes into a brick wall at 50 miles an hour. If the car is like solid steel, then most of that force is going to go onto that body and it's going to do tremendous damage. So part of breaking down that force, so that less force hits the body, involves the car collapsing on purpose by design. But that's generally a vehicle against another vehicle, not something like this here. Judy said that Marky Mark said, keep about the feds, keep them in the dark. They're like mushrooms. Yep. I think he said feed them shit and keep them in the dark. Coffee Kristen said the hive mind is working on how to spin it so it's good for Karen and conspiracy theories. I don't think today was a good day for the defense. I thought last Tuesday was a better day for the defense with those revelations. But I thought today those revelations tended to show there's no conspiracy. Nathan says a glancing blow that sent him 12 feet. Yeah, and we don't know if he was, I don't mean he was launched in the air. I just mean that's force pushed him back, and that's where he ended up. Yeah, so Frank Perry says that if someone had flipped, Josh Levy would be having a bunch of high-profile arrests. There would definitely be indictments. If Higgins had flipped, there would be indictments, period. There's just, and we would know about them. So no one has flipped here. Steven says, if he was launched, how did his arm get cut up? Now, just to repeat, as I've said many times, we don't know what the state's accident reconstruction theory is. And if they don't have a convincing one at the trial, Karen's going to get off. I mean, it's really difficult to accuse someone of vehicular homicide and you don't have a theory about how the injuries happened and how the vehicle was damaged. So we don't know what it is, and we don't know if it'll be convincing. That said, how did the arm get those injuries? Don't know, but my guess would be if he had the cocktail glass in his hand and it kind of hit his arm and the glass at the same time, there would be damage on the arm. Actually, someone just reached out to me the other day that they work in a hospital and they just saw a similar, not exactly similar, but where someone was struck in the arm, a pedestrian was struck, and it ended up with very similar type injuries. Oh, also, I mentioned this on Twitter the other day. So when I was doing research this week on accident reconstructions, I may have the answer as to why the car was towed to Canton. And I quoted this. I quoted this right from this training video that said it's recommended that if you have the opportunity in any pedestrian accident like that, that you afterwards take the vehicle or a same model vehicle back to that scene, if possible. And the reason is you want to look at things like, for instance, did did the driver have a clear point of view? And so they could have avoided this person. Just all kinds of environmental things. But it actually said that it's advisable to take the vehicle back to the scene. So I'm going to guess, and I have no inside information on this. I'm going to guess that what we're going to find out is that it's policy in pedestrian accidents to return the vehicle as close to the scene as possible. And that's what we're going to find out. And that's why it went to Canton. Now, I don't know. It could be some other reason. I've never been able to find out. I've talked to a lot of people involved with different aspects of this, and no one really knows. But I think it's going to end up, like most of these things, it ends up being a mundane explanation. Just reading through the comments. Oh, yeah. He points out something interesting. So, let's see. Let me pop this up here. All right. So Jason Cutler says Higgins was clearly avoiding Brian Albert for a period of time, and his lawyer said he was cooperating with both sides in the feds. Does this mean he flipped? No, he definitely didn't flip because he was indicted. But it is interesting if he was avoiding him. It sounds like, but that's the way Yannetti portrays it. Keep that in mind. So we don't actually know that he was avoiding him. I think this is just Yannetti's description of things, but it would be interesting if he was avoiding him, right? So, and what are the reasons for that? Who knows? What did you guys think of Yannetti's performance without Alan Jackson? Do you think he's as good as Jackson? Do you think he's better? Not as good? Carrie says, I can't believe there are people on here still arguing this nonsense after that hearing. Yeah, you really, but Carrie, you do have to kind of parse things through. There are odd things, right? And some of them were revealed today, and Yannetti gets to make his side's point. To me, it was a really bad day for the defense but that's only for if you really sit down and think it through. But if you really sit down and think it through, the feds had all the communications and they didn't find any evidence of a conspiracy. No one's been indicted. So for people that sit there and say, oh, well, they found it and it's just still coming, come on. That's just not even reasonable. No one's been indicted. Nobody has received a target letter. None of the investigators have been put on leave or suspended or anything like that. They're all still working. And I can tell you that with certainty, that they're all still working. And it doesn't sound to me like the IA thing is going to be a big deal either. That everybody's agreed that material will be turned over right away, and Proctor's not opposing it either. Judy's talking about Grant's mentioning that Karen Reed returned to the scene. Well, it's always been implied in the charging document that she might have, but the defense counter is that they don't have the evidence for it. And so that was one of the indications to me by both sides that the GPS was off, because if the GPS in Karen's phone was on, we'd know where she went, right? And we know she had her phone because she was using it, because the state talks about tracking some of her calls. In fact, when you read the state document closely, it's clear that the GPS was off, but they were able to track her to some degree because of activities she was making on the phone. So if you make a call or send a message, that location leaves an imprint. So even if your GPS is off, that stuff is still on. Now, it's also the case that your car has a GPS chip in it, especially any new cars. And that was a new Lexus 2021 model. It's going to have a GPS chip in it. So the question is how much data they were able to get. You have the black box stuff, but there's various sensors and data streams that are running and being recorded in different ways inside that vehicle. They had trouble accessing the entertainment system data, which could really have a wealth of stuff. And they weren't able to access that until December 1st this year. Both sides had to have, it's a destructive process. Once you unplug it, you lose it. So both sides had to have their representatives there when they took it off. And you notice today the judge, that's not brought up as something that's still outstanding. The only thing outstanding is actually something from the lab that they mentioned, which was presumably DNA. So that means the data from the car, to the extent that it exists, that they have it. Both sides have it. Now, hopefully, we don't know what's in it though. Was any of that data destroyed? Were they not able to get? For a while, there was a discussion that the software for that company that runs that manufactures that entertainment system had not yet been written in a way that could read the data. So we don't know what the status of that is. Nathan, how the body got 12 feet from the road. A 2-ton vehicle barreling at you at 23 miles an hour and making enough contact to break the taillight is going to send you pretty far. It's going to send you pretty far. Yes, celebrates the gold standard. Kerry, you're right. I don't think there's any evidence that he crawled from the road. I think he was hit. Like I just said, I just came in a couple minutes after a motorcycle accident yesterday, and I couldn't believe. And it had to be low speed because it's a road that the speed limit is, I don't know, maybe 20, 25 miles an hour. It's not. And it's also at the time of day when there's a lot of cars on it because it's near the high school and there was actually a lot of joggers in the area too. The high school track team was out. There was about like 50 girls, like high school age girls, all jogging around this area. And 2 of them had witnessed what had happened and were over helping the victim, who, as I got a little closer, saw that it was a motorcycle that must have lost control, smashed, say, between 20 and 30 miles an hour into the SUV. And that lawn, he landed about 20 feet onto the lawn. So again, it's not exactly the same situation, but it shows how powerful, how far a body can be launched. I said, I showed maybe a month ago, another story with this high school age girl who was in a car accident. It rolled over a bunch of times. It was supposedly not high speed. I think it was like 25 to 30 miles an hour. But let's say maybe she was speeding a little more than that. I don't know. But she rolled. The terrain was flat. She rolled into a utility pole, and the force of that launched her so high into the air that she ended up dangling on a power line. And she lived, but she was on that power line for hours because it was very different. It was, you had to get the power turned off. And ultimately, so she was hanging, her arm had been severed, but was hanging by a piece of skin. And I think they saved the arm, but she lost a leg as a part of that. But when you see the image of it, it launched. I mean, it's got to be 30 feet high. It's a high power line and launched her all the way up in the air and left her on top of that power line. So there's a lot of force involved in these accidents. The glass was indeed found by the cocktail glass pieces, and the straw were found by his body. All right, trying to get caught up. Ms. Mule, that seems a new name to me, so I want to say hi. Hi, nice to meet you, Ms. Mule. Kevin, I appreciate your views on this case and enjoy listening to your live streams. Unfortunately, the internet is full of people who spew vitriol and have no qualms about sharing it. Yeah, but most people here are pretty civil, so it's pretty good. But yeah, there are a lot of people that are spewing stuff, and sadly, there's a lot of stupidity too. But review the evidence of the Klaus von Bülow trial. I actually, when I was in high school, I loved Alan Dershowitz's books, and he had his first book covered all those cases, famous cases that he had been lead defense on. One of them was Klaus von Bülow. So I read that book, but that was 40 years ago. So I don't remember anything about it, but I do recommend. A lot of people might have different opinions on Alan on Alan Dershowitz. One of my best friend from college is now a judge. He's not and he's a liberal judge, but he's not a fan of Dershowitz for some reason. I don't agree with Dershowitz necessarily politically, but I love him as a lawyer, and I love the clear writing. And was almost enough to make me want to be a defense lawyer, but not enough. And I'm not smart enough for that. All right. Well, you were given a chance, A, B, G, so we're just going to have to ban you. So, Comfort and Joy asked, Nathan, what is the importance of where the glass was found again? I mean, where all the evidence was found is important. And that's what an accident reconstruction team will determine. I mean, and these people that do this for a living, there's a ton to learn. And we don't know. And stuff that every cop that I've talked to says the stuff that goes on with pedestrian accidents, especially, is just the amazing stuff that happens to the human body and the objects around it. It's just, and no two accidents seem to look alike. But if you're an expert, you understand what's going on. So presumably we'll hear that at a trial, but all that stuff is relevant. And as this was a very unique case with a storm, this was in the early stages of a heavy snowfall. So, and the state police didn't arrive to investigate until, 11 hours later? Probably about 11 hours later. And in that time, in the meantime, over a foot of snow had fallen. So all of that impacts the way the investigation unfolded. What part of the body got hit to send him flying if it was the glass? So if you're facing across the street and you got your drink like this and a car backs into you at high speed, it hits the glass and then also hits your body, but it hits the glass a fraction of a second before. That's me as an amateur saying this. I do not have any idea what the state's accident reconstruction theory is. I managed to get many months ago one question to Michael Proctor, but I was very aware of not wanting to in any way jeopardize a case or involve any kind of anything confidential. And I'm sure he was the exact same way. And every indication I've had is he stays quiet on all this stuff. But my question I thought was vague enough. So what I asked was, does the state have an accident reconstruction theory that it's confident in? And the one word answer that came back was yes. But what that theory is, I have no idea. And I can't wait to find out in trial. And I hope that would be the case. Hopefully that trial still goes on in April. Michaela says they wouldn't be the targets. I'm not sure you're talking about, but so let's say Higgins witnessed a crime in the house and didn't call an ambulance, didn't call the police, didn't intervene in any way. That's a crime. It's a crime for anybody, but it's especially a crime for a federal agent. So if days later he came forward to cooperate, or weeks later, or months later, or whenever, or even hours later, he's still going to be indicted for what he didn't do that day. He's still going to be indicted for the role that he played. Now, that's people make plea deals. They come forward and they say, all right, I'm going to come clean. I'm going to tell you everything that happened, but give me a good deal. So he may not get jail time, or he may get less jail time, but that's how it works. That's a plea deal still involves an indictment. So if Higgins flipped, that means he was indicted. All right. Or he's going to be indicted. And he would have definitely received a target letter. And none of these people have received a target letter. And as soon as the feds had evidence that there was some kind of a wrongdoing on the part of any of them, there would be target letters involved. You know, and the U.S. attorney didn't have to talk to those guys' lawyers. So Kevin Albert, Brian Albert, and Brian Higgins. He didn't have to talk to their lawyers. You notice when the state reached out to them, the district attorney, over a period of many months, they just ignored all the letters. They don't have to comply. They can just say that's under investigation and we don't talk about it. They didn't say that. They said, no, your client is not a target. And that's why I say this was a bad day for the defense, because to have that come out, that was big. That was big. And it didn't come out from Lally. It came out from their lawyers. But it's pretty hard to have a cover up and have none of the main people involved be aware of it and be guilty of some kind of crime. So it's really thin here to think. There's not much to cling to anymore for a conspiracy theory. There really isn't. Now, do I think that this trial might be delayed because of those motions for the phones? Maybe. You know, I don't know. I don't know what the judge is going to rule there. I don't think she wants to, because she knows, she can tell that it's irrelevant. But she, you know, that's not going to be part of her thinking. Her thinking has to be, you have to rule based on precedent and law. So I don't know. Is that material relevant? I don't know. To me, the feds have all that stuff, so we know they didn't find anything, or there would have been indictments. It's called Celebrite software. So if they use the search, I'm reading Frank's question, and the FBI expert testified. The first question, the prosecutor, is, did you or have you used this? I think you mean Celebrite software. I'm not really sure what you're saying. So Michaela says the FBI is investigating the investigation. Yeah, no, well, not only that, but we know for sure that the state is investigating the FBI's investigation. And I would say that it's going to be very likely, a certainty, that if no conspiracy was found, and all the evidence is that no conspiracy was found, then you're going to have other agencies within the feds. So the IG's office and the ethics office are going to be investigating the conduct of the U.S. attorney. That's probably already ongoing, but if it's not, it will be as soon as this case wraps up. There's a lot of shady stuff that went on here, and I'm just look, I'm suspicious of everybody, right? You know, but I'm extra suspicious of the feds. Not that there aren't thousands of great men and women that work for the federal government and these agencies trying to protect us. There are. But there's also, especially when you get in the Washington aspect of it, or people that want to get to Washington, there's a lot of very ambitious people, maybe people that don't have a lot of street smarts too. I mean, there's just a lot of, I just have seen too much bad shit. And the feds, the FBI, if it wasn't for the FBI, Richard Allen, who's on trial for murdering Abby and Libby, and who's confessed to it in jail to his wife, Richard Allen would have been caught 6 years ago, 7 years ago now at this point, if it was not for the FBI. The FBI screwed that investigation up because they had no common sense, not because they were corrupt, but they had tunnel vision, they had poor judgment, and they had no common sense. We'll go over into that. I've been over that before, so I'm not going to get into it here. But the FBI screwed that investigation up. And that murderer stayed out. Now, fortunately, he doesn't seem to have killed anybody else after that, but he could have, because the FBI was incompetent in that case. And that's just, it is what it is. I'm not saying that the FBI is always incompetent. No, there are obviously a huge number of very competent men and women there. But I just don't have a very, I don't know. I don't have an overall a very positive opinion of it. Now, there is going to be a future guest here, someone who I've talked to that I think maybe will change my mind on some of that. And also, I had on several episodes with Wayne Miller, retired from ATF, who exposed some big investigations. And that guy was like, everything he said was very compelling to me about his honesty and integrity and the effectiveness which the way he did his job. So there are good guys out there, no question. Scott, thank you very much for the contribution. Scott says, another very interesting hearing. We'll put it, let's show his comment up there. Another very interesting hearing. Do you take the statement about Brian Albert and Higgins not being under investigation at face value? Yeah. I don't, I have no reason not to, but I guess we shouldn't take anything at face value, right? But it's really not the kind, for a lawyer to go before a judge and lie, you can get disbarred. Now, Alan Jackson does it all the time, but he walks right as far up to a lie as you can get away with, and then wordsmiths it so that he could always say, well, it wasn't quite a lie. And that's what he does. That's what he's a master at. The non-human hair, that kind of stuff. He does it all the time. Basically, on the hearing last week, he said the state, it's not his fault. The state didn't have the 2023 version of Celebrite in 2022. I mean, it's crazy though, because the state doesn't have a time machine that I know of. So the state could not have had the 2023 version of the software. They had the most updated version, just like you have the most updated software on your phone right now. But there's going to be a different update that comes next year. You can't get it now, and the state couldn't do it either. So is it a lie? I mean, he wordsmiths it, so. Oh, I see I'm pretty way behind on the comments. I'm sorry, guys. Tom, I'm seeing your question now, but I'm a half hour behind, so it's hard to get caught up. But yeah, I think I addressed it. So let me try to skip. All right, so that means I'm skipping over a bunch of questions now, and I apologize. So I'm jumping all the way to the end so we can wrap this up soon. And just want to say, for anybody that's listening, for anybody that's here, and for the vast majority of people here on both sides of being civil, I very much appreciate it. Tom Fleming certainly appreciates it. So thank you. Let's have civil discussion on these cases. On April 20th, if you're interested, we're going to the Lizzie Borden house, April 20th. There's a limited number of tickets. This is not something we're making any money off. We're trying to get the best deal we can for people. We can get a 10% discount if we get 20 people, but it's capped at 25 because only 20. It's an hour-long tour, and they can only take 25 people into the house at time. And then we're going to get together afterwards and have lunch. I think the place is called Scotty's. So I got to put together the event more formally, but Scotty's Pub. So it is a place you can have some beverages. So if you want to join us, it's a Saturday, April 20th. The tour will begin at 11:30, so you got to be there at 11:15. This is in Fall River, Massachusetts. It's a little drive for me, but it should be fun, And I have a whole series on the Lizzie Borden case that if you want, that was an early series I did a year and a half ago, so people can check that out if they want to get up to date on it. There's also plenty of websites and stuff I can recommend to you. If you're going to do the tour, it is better to know something about what happened and the mysteries that linger in that murder. So again, that's April 20th. Yep, and Carrie Lama was the one that chose the date for us. So thank you, Carrie. Carrie will be there with us, and Dave McGrath will be there with us, and we should have a lot of fun. And you're welcome. Whatever you think is going on in the Free Karen Reed case, whether you're Free Karen Reed or whether you think she's guilty, because we're not going to discuss Karen Reed that day. It's going to be a non-Karen Reed day. Yes, it's in Fall River. It's almost exactly across the street from the new courthouse. Fall River's, kind of a rough and tumble rundown kind of place, but it's in the day, it's on a Saturday, and it's across from the courthouse. So I think you're pretty safe there. One when I've been there once, like 10 years ago, and there was plenty of parking on the street. Depending on what time you get there, you may have to park, quarter mile away or something, but there seemed to be plenty of parking there. There's actually like a nice, weirdly out of place, some kind of monastery that's maybe, I don't know, half mile up the road or something like that. That looked really nice and really pleasant, but it's a lengthy piece of property. So there's a lot of parking spaces along that. So Fall River in Massachusetts, that's south. So kind of close to the Rhode Island border, down near New Bedford. Yeah, Fall River. Oh, look, Emily's in Tennessee. Oh, Lord. That's a long drive. I wonder if Emily follows the grifter. He's from Tennessee. Dave can be everyone's bodyguard. Yep. Kevin saying that Albert and Higgins aren't under investigation is gaslighting. We all know it. It's the DA's office and the state police. Albert, Higgins, McCabe, etc. will be arrested. No, that's not going to happen, dude, because when I'm saying they're not under investigation, I'm saying the feds have not given them a target letter. They certainly have not indicted them, and they have not given them a target letter. And that's seems to be confirmed, and nobody objects, nobody disputes it. So, well, their lawyers said that they talked to the U.S. attorney, and the U.S. attorney says, no, they are not targets. And that's a powerful thing. That's a formal thing to say that. They could have said nothing. The U.S. attorney could have said nothing. But he said, no, they are not targets. Now, at this point, after everything they've uncovered, all the feds can get all these communications, and they get them without a warrant. They just ask the phone companies and Google, whatever, and those companies just hand them over. Facebook, Twitter. They give it, these big companies just give it over rather than deal with fighting the feds. So it's a little disturbing. They don't even have to get a warrant, but they don't. They just get this information. So the feds have it all, and they have not indicted. They have not put down. They've not sent any of these guys. They've not made any of them targets. That's powerful. And those lawyers are not going to get up and lie about that in front of a judge. Because if all of a sudden the U.S. attorney gets to them tomorrow and say, we never had that conversation with that lawyer is going to get disbarred. You don't lie to a judge. Emily says, I used to subscribe to the Glare, but this case has made me question his ethics or lack thereof. So I unsubscribed a while back. I can't support someone like him. Good for you, Emily. Yeah, total grifter. To me, a grifter is someone that doesn't care about the truth, isn't pursuing it. To me, so if you got something wrong, that doesn't make you a grifter. If you have an opinion that ultimately turns out wrong, that doesn't make you a grifter, as long as you're pursuing the truth. As long as the truth is the main thing you're pursuing. If the main thing you're pursuing is subscribers and donations, then you're probably a grifter. And then the other aspect of it, to me, it was two aspects. One is you don't care about the truth. And two, you don't care about what innocent people you smear. So if you're smearing innocent people and you have absolutely no concern about that, then you're a low-life grifter. And there's no way around it. There's no way around it. So to me, even if by some absurd twist of fate, there turns out to be a conspiracy here, a cover-up, the Glarer is a grifter. All right. And so are any of the other channels that don't make any effort to pursue the truth. Because if you're not making any effort to pursue the truth and you don't care who you're smearing, you're a grifter. You're just, I don't, and people, I've heard people say, oh, this guy's an idiot. I don't know that he's an idiot. He's probably not. He's probably a pretty smart guy. He's just a guy. It's a grift. Usually people that grift are pretty smart. They know how to make money off the grift. And that's, so that's all, so to me, I don't say he's an idiot. I doubt he is. I only really heard him a couple of times. His coverage of this case was idiotic, but I don't think he's necessarily an idiot, because I think he's just kind of slanting his coverage on purpose in order to appeal to the turtle riders and the Free Karen Reed crowd. So, but who knows? I mean, but in any case you go into, if you're not asking hard questions from both sides, eventually you're going to end up with having a very weak understanding of things. I mean, at least ask hard questions of both sides. That's all you should do. Now, eventually you'll get to an opinion, right? But just keep asking hard questions. So everything that comes up in this question, I try to look at it in isolation and try to interpret the different things. And then in addition to that, I also try to fit it into the larger context. So for instance, 227, first you treat it in isolation. Is it possible that that search was made? What do the experts say? What are the explanations for all this? You look at that in isolation. But then there is also a sense that if you look at it in the larger context, so to me, 227 always had a very proportional relationship with the planting of evidence. So to the extent that planting of evidence was impossible, then that also made the 227 search much less likely, because there's no conspiracy here unless evidence was planted, including that main piece of evidence. There's no conspiracy unless evidence was planted. All right. And if 227 happened, if that search actually happened, then there is a conspiracy. So if, to the extent that evidence was impossible to plant, then that 227 search didn't happen. So it has that proportional relationship to it. So that's why you look at the evidence in isolation, but you also look at the whole thing. Caitlin, welcome. You must have just got out of work. But Emily, I would love to visit Tennessee. Actually my sister and my niece are going to Tennessee in the near future. And a lot of people are moving to Memphis, right? A lot of famous people. So I think Tennessee has that great history and the great beauty of the landscape, but it's also on the rise economically, hopefully. Oh, so Emily's talking about the making of a murder. No, I didn't follow that case closely, but Davis McGrath has told me a lot about it. So yeah, and it was very easy to hook people into that. But then even so much so that even once the evidence came out that showed there was no conspiracy, you couldn't move people. Many people that had already bought into it, you couldn't move it off them. You couldn't move them off it. I mean, that's it. They were hooked. And I think that'll happen here too. I mean, it's one of those things that even if Karen confesses, a lot of people just aren't going to accept it. Joe says, how can you have a conspiracy if we just heard the feds didn't give the target letter to Brian Higgins? Yeah, absolutely. That's what we've been saying, Joe. Welcome aboard, and you're with us. I think that's what most of us think. It becomes almost untenable to think that there was a conspiracy that the feds exposed here. So if there is a conspiracy, if there is a cover-up, the feds failed to find it. I think that's the only reasonable thing to conclude at this point. Not that we've, in the public, had access to what's in those, but you can read between the lines of what's said and what's not said on these cases. So, and Emily, too, I mean, we all love a good conspiracy. Some conspiracies do happen. There's no question that there was a conspiracy. Don't get upset, guys. This is not a partisan comment. There's no question that there was a conspiracy that involved a lot of powerful people and the media to try to create the impression that Trump was a Russian spy. Trump may as many things. If you want to say he's an idiot or this and that or fine, whatever. He's not a Russian spy. And we know exactly how that conspiracy evolved now, too. So, there are real conspiracies out there. And so it's worth but they're rare. And the bigger they are, the more rare they are. The more people that are involved to make it happen. But that doesn't mean it's still not interesting to look into stuff. But if you're looking into the JFK conspiracy or whether we landed on the moon or something like that, we're not really hurting anybody anymore at this point. These things happened such a long time ago. But if you're going to take every crime that is going on now, and obviously Emily doesn't do this. I'm saying someone is going to do that. And you're going to try to turn that into a conspiracy. And there are whole YouTube channels that play that angle. You're harming innocent people. There's no question you're harming innocent people. I mean, you're accusing innocent people that have no evidence against them of being part of a conspiracy. And, that's a problem. So I just want to say, looking at the numbers, we get a sense, if you're watching on YouTube, you get a very different sense. So right now on YouTube is only 84 people, but on Twitter is almost 900. It's one short of 900. So it's weird. It's like most of the people that watch this on Twitter. So we become kind of a Twitter channel, whatever. I guess because I put the links there. All right, so let's just do one more question and then call it a day because I get tired. My back gets stiff sitting in this chair all day. So, and these hearings can be long. So if you are listening on Twitter, do us a solid. Go on to YouTube for 1 second. Just hit the link and just click subscribe so we can somehow get to 5,000. That's like a magic number for us. 800 of them are bots probably. Why? I don't, maybe, but why would they be bot? I don't know. We do get, if you look at the comments, we get a lot of comments there and a lot of clicks there. So I don't know. Joey Diego is commenting that they're still harassing and following them when they leave court. Yep. Oh, Delcina 363 said she was listening on Twitter and she came in. Thank you very much for doing that. See, you guys can do it. You can help us out. Pop in here and click subscribe if you could. I'd appreciate it. Doesn't cost you any money to click subscribe. Just a little bit of support. Appreciate it. And Emily says they were calling Jen murderer and liar. Yeah, it's just the way people conduct themselves is so, it's very disturbing to think that even if you think that there's something funny going on here, to be so sure that you're going around calling people that aren't criminals, calling them murderers, people that have family, that have kids living in their house, it's disgusting. David Coffee says David Yannetti did not need to argue in the hearing about Brian Albert's intimate relations with his wife. Totally gratuitous. Yeah, that's true. But it does, gives us an insight as to why people hide their phone data and it doesn't have anything to do with the conspiracy. Turtle Boy, of course, has already tweeted mocking him for that. Turtle Boy's mocking Yannetti? Wow. Maybe we'll have to have a bout between Turtle Boy and Yannetti soon. We're going to get that bout Sunday between Turtle Boy and Sean. Looper says Turtle Boy is a self-promoting hustler, but puts it in a question mark. So she may be just questioning that. I mean, there's nothing wrong with self-promotion. Everybody has to do it in life. Just pursue the truth. Have a sense of ethics about what you're doing. If you don't, then yeah, you're a hustler. If you're just trying to swindle people into believe things that you probably don't even yourself believe. Coffee said she was watching Tom's CPU when the woman knocked the camera out of his hand. So I was on live, so I didn't see this. Been hearing a little bit about it. I don't know. He does seem to be intrusive in the way he tries to get into filming people that don't want to be filmed, that aren't part of the case. But all right. So let's call it a night, guys. Again, we'll be looking into the Evansdale murders. We're doing that now. So anybody that wants to join us on that or is interested in the case, reach out to me. We'll be talking to Bill Noguera next week, who's in prison and has been in prison for 40 years, initially on a death sentence. And now he's serving a life sentence. Really intelligent guy that has a lot of insights. We'd like to even maybe make a trip out to Iowa and look into this, but that's a little ambitious, so we'll see. But we are making a trip to the Lizzie Borden house on April 20th, so please join us. Comfort and joy. I'm not going to repeat that text. I've heard that for a long time, but because it was attorney-client privilege, it's inadmissible, so I avoid it. But I can say that Turtle Boy was told it this past October. He knows about it too. He was told by his lawyer. So slatherings, I think I'm under our X fault. There's a couple of fake ones out there trying to be me, but feeding out disinformation. There's one called Care from Yellow Cottage 69. That's a fake one. Mine is from our X fault, which was a name that I made before Twitter, like a year or two before Twitter switched to X. So it ends up being a kind of a good name, I guess. But all right, guys, I hope you have a good night. And if you're a basketball fan, enjoy tonight the Celtics versus the Bucks.